Hello, can I get your name?
Adriana OA. I was going to tell you, I know I have warrants for South Tucson. That day I got released from here. I went over there, but I got picked up by the ARC and the lady was taking forever. So I was on.
Ma'am, just 1 second. Let me go ahead and let you know what your rights are first, okay? Because I don't want you to accidentally say something that might wind up hurting your case. So we do have you, we're seeing you today because of those warrants out of South Tucson. Now, you do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and I'm going to appoint Michael Vaughn to represent you. You'll get paperwork that has his information on it.
Okay. But I completed the treatment that they wanted, and I did the DV. I did DV classes and all. I finished everything. I just hadn't had time to go down there. My dad just had surgery in his brain, so I'm helping him with my last two.
All right, ma'am. Well, I'm certainly sympathetic. This is a number of cases, and regardless of what was going on, at the very least, you could have phoned South Tucson to try to get things rescheduled. I am showing in one case you've got the disorderly conduct, in another you've got criminal damage and disorderly conduct, and also criminal trespass in another, and the fourth case is also disorderly conduct. So I am going to order you be held on the $200 cash or secured bond listed in the warrant. You are not to possess any alcohol, illegal drugs, firearms, or weapons. 1 second, ma'am. I see your hand, and I'll let you ask a question here in a second. You're also not to commit any acts of domestic violence. Your next court date will be on August the 4th, so that will be tomorrow, and that will be at 10 o'clock in the morning. What was your question, ma'am?
I just got a phone yesterday, so that was my whole plan of calling him on Monday. Can you just please give me this chance? I did everything I was supposed to. Just this one chance. That's all I'm asking for. I need to help my dad, my kids, like to go to school. So if you can please.
All right, ma'am. You've got your court hearing tomorrow morning, which is the soonest that it can be scheduled, and you've got 4 open cases. My order stands, and you're excused.
But Judge, the kids. No, actually, good job, Judge. Fantastic. I love it. My order stands. I said what I said. Next.
All right, Mr. Weaver is here on unlawful possession of metal or body armor by a felon.
Zach over at LawNerdsUnite sent me this. It's it's pretty good. The guy's living in an alternate reality, which is frankly a good assessment of the situation.
Felon and possession of drugs. Risk assessment level is a 3. 2014 conviction for harassment of a public servant, multiple misdemeanors. The most serious is a 2014 terroristic threat against the public servant that was reduced to a misdemeanor. And he says he has no money for bond. Mr. Chevrier.
Yes, Judge. Mr. Weaver, my name is Adam Chevrier. I'm with the Public Defender's Office. We're here at your bond reduction hearing. I'm trying to see if we can get the court to potentially reduce your bond on these matters. And so I'm going to ask you a few questions just to see if we might be able to get a reduction from the court, okay? Can you hear me okay, Mr. Weaver?
Yes.
Okay. Mr. Weaver, are you a U.S. citizen by chance?
Yes, I believe so.
I'm sorry. Are you able to step a little closer to the camera, sir?
I believe, yes, I'm a citizen.
Okay.
I don't know much these days. I don't know.
Sure. Okay.
I've created some kind of weird reality. Everything has changed. I have no idea what's going on. I don't know.
Okay. Well, right now we're doing a bond hearing because you've been arrested on a couple of charges, and right now we're doing a bond hearing over Zoom.
Mr. Chevrier, did he says he lived on a different reality?
It seems there may be some mental health concerns, Judge.
All right. I'm going to
Your Honor, may I? In regards to the unlawful possession of body armor by a felon, when law enforcement went where the defendant was, he had a BB gun holstered and several large knives. And at one point, he held a knife to his throat. And so that was EDO. And at the hospital, that's when they discovered he was wearing the vest, Your Honor.
Okay, I'm gonna order
But it's all okay because he lives in an alternate reality where all that's cool.
1622. I'm gonna reset this matter to Thursday. Is there an EDO pending, or is that where they went?
That's when where they went, Your Honor.
They went to the hospital?
That they went to his residence and then they placed him under EDO because he was holding a knife to his throat.
Okay, so when they placed him on a, give me a second, when they placed him on an EDO, did they transport him to the hospital?
Yes, Your Honor.
Okay, and then after he was released from the hospital, he was brought over here?
After the hospital, Your Honor, I'm assuming that they released him because the possession of the narcotics, what is it, of methamphetamine, that occurred on the 31st.
Okay, all right, so I'm gonna reset him to the 7th of August. 7/2025 at 1:30 p.m. Need a safety plan, and I'll order it at 1622, Mr. Chevrier.
Thank you. And is my office representing him? Do we have an attorney
Yes.
on him?
Yes, your office is representing him.
Thank you.
All right, thank you, Mr. Weaver.
Hold on, wait.
Ultimately, I agree with the defendant here. He's fried his brain on drugs. He does not have a grip on reality, and he basically saved everybody time just stating it openly.
Okay, so I'm confused.
What happened is I'm going to reset your case till Thursday. Somebody from the public defender's office is going to go speak with you, including a social worker. Okay, they're going to create a safety plan so that if I do release you on Thursday, I want to make sure that you're going to be safe. I want to make sure that you're not going to hurt yourself or hurt someone else. Do you understand?
Yeah, I would just like for someone to explain to me. It's not that I live in a different reality. It's
Okay.
I've said some things working with Perplexity AI that I think may have changed some things in reality. And like, when did we get regions and districts in El Paso? That's new to me.
When did we get what?
Regions, like when did we get like central region? And
I think he's at the central point now. When did we get regions and districts in El Paso? I think if we get to the bottom of that, whatever the hell he means, then we can feel comfortable leaving him in jail where he belongs.
like, when did that happen in El Paso? Why doesn't this
Somebody from the public defender's office will go and speak with you, and you can ask them all of those questions. Thank you, sir, and best of luck to you.
All right, appearances for People versus Littleton.
Okay, here's one of those clips that literally everybody sent to me. This went down, I don't know, 3 or 4 days ago. I didn't do it. Everybody else did, but it's fun. It's fun. Let's take a look. I have lived this in real life. I have been to this party. It's pretty fun, especially with Judge Oakley.
Morning, Honorable Smith, more on behalf of the people, E847240. Good morning, Your Honor, Attorney Silvana Cross, and you, James Case, and I am on behalf of Littleton. Littleton, division,
All right, ladies, we ready to go?
yes, Judge, the people are ready to go, and I have plenty witness who flew in from out of the country to be here today.
All right, put her on the stand.
Your Honor, I mean, Mr. Littleton, to refer the competency at this time, the defense counsel is adamant that Mr. Littleton is no way understanding the nature or the object of the proceeding and cannot. But he is not fully aware, Your Honor, when I try to ask him or explain to him that I'm his attorney. He doesn't.
Let me stop you. When did you talk to him and realize you had those problems?
Well, it's been a compounded conversation. So it was the first one. It was a little off. If Your Honor was, I'm not sure if Your Honor was the judge that At that time.
Was not.
Statements saying that I didn't think any.
Counsel, my question was a simple one. When did you know you had this problem?
Sometimes it's a compounded issue, Your Honor. It wasn't just the first time, it was the second time also.
Denied. Denied. Twice I've asked you a direct question, you can't answer it. No, I asked you for a date. When did you know you had the problem? They flew somebody in from out of the country. If this was a problem you could have told them about a week ago, we could have avoided that. So we'll go ahead with the exam. You can do whatever you want. You can build whatever your record is. We're going to use the witnesses that are here today.
This one
I didn't ask for an argument, counsel. I just told you my decision.
going to be completely, I think this should be ready, and I want to be upon Mr. Wilson. I have no opportunity to review the discovery. I'm not the attorney of record.
Okay. So the judge is spot on here. This is what's going to happen in this situation. Why I say I've been to this party, it may be hard to believe, but I was young once. And this is the sort of assignment you get at a law firm. Why don't you go, clearly we've screwed up. Why don't you go catch a spear for me, young associate? And it's done on purpose. It's done on purpose because they know the judge will feel sorry for you. They know that you've been thrown in, and they know it's not your fault. Judge Oakley's on top of it. He parses it all out. He knows who to be mad at. This girl, God bless her, she tries, but she does not know what to say, and she does not know when to stop. But she is taking one for the team here, big time. And that's fine and all. But Oakley's got a witness in from out of the country, and he's not happy. And no judge worth anything would be.
Then why are you here? Who's the attorney of record?
And that is correct, Judge, as much as Mr.
So schedule a show cause for Attorney King for contempt of court. Would somebody like to explain to me why the attorney of record is not here for a scheduled exam?
Understanding when it's a different matter that he's explaining to his father because I was going to come here anyway, and because Mr. Milton was going to refer to competence.
No, he wasn't. No, he wasn't. You were going to ask for that.
The court, the statute requires that the court at least consider that the referral to competency at this point in time juncture. I understand that there has been a delay in the complaints from out of the country. However, the statute is very clear, and if Mr. Littleton and not assist rationally not comprehend what is actually happening, actually they cannot move forward. And I think the court has an obligation to consider.
Here's what I consider. Your office is continuing to do this to the court docket with attorneys that are scheduled that don't show, don't call, just ghost us. We've got attorneys that show up the day of the exam having never spoken to their defendant repeatedly, day in, day out. Every Wednesday we have the same thing. Your office is disrespecting the Wayne County bench. Is that clear? We've been told we have to actually hold you people in contempt so that they can withhold the payment for the job that you're not doing. Would you like to say anything?
Judge, I just asked for an opportunity to make a fair record, if I may.
Go ahead.
So first of all, I would like to note that this is my first time actually working with Ms. Barrage. This is not, I believe, her choice. I believe she was sent here by Mr. King.
Oh, it sounds like they threw her to the wolves.
I just want to acknowledge that. I don't think that this is a problem for me.
No, she's just lucky enough to be the one I yell at. No.
Judge, I contacted Mr. King. I called NDS last week, contacted them specifically so that I could figure out the head of the PCC, the defense attorney was. I found out that it was Mr. King. I contacted Mr. King. I got a hold of him that day. It was the day before the probable cause conference. I let him know that I was personally sending him the digital discoveries so that he could review it. I indicated that there may be some competency concerns, and I asked if he would let me know if he would be referring for competency. I also let him know that I spoke to the out of the country complaining witness, confirmed the next 4 to 6 Wednesdays her free in her schedule and let him know that we were flying her in, and told Mr. King that I would make any of those days work, but that if we scheduled an exam for her to be flown into the country, and Judge, this is very important, this happened at the airport, so flown into the airport, that she was sexually assaulted in, that if that happened and if she came here, we were holding this exam. Because I was not going to have the victim come all the way back here, only to be told that there was an adjournment request or have to be referred for competency. I asked Mr. King that. I did feel at the time like he was dismissing me, but I also recognized it was pre-PCC. The PCC happened. I appeared early. I was not present when the actual date was set. It was set for 7 days out. We did everything that we could to get the victim here. I had the officer in charge meet her where her plane landed at the actual gate to get her from the gate through the airport. Again, she was sexually assaulted into her hotel to keep her calm because she's been extremely traumatized as a result of this. Prior to this, after all the arrangements were made, I started calling Mr. King 48 hours before the victim needed to leave to come here, just to confirm that he was not planning on asking for an adjournment for discovery, to confirm that he was not planning on referring the defendant for competency. He refused to call me back, refused to answer my text. I got a call from him this morning at 8:30. It was the first time he has spoken to me since pre-PCC last week. And that is when he told me that he had not spoken to his client, that other members of his team had fortunately stepped in to speak to his client for him, and that they were concerned about his competency, and that he wasn't sure if the defendant would be able to sit through with this hearing today.
This is totally unconscionable.
Which I told Mr. King that we would address the, because to be fair, Judge,
Mr. King better bring a toothbrush when he comes for the show cause. Please send that message. Clear? Counsel? Clear? Answer my question. Clear? Make sure he brings a toothbrush when he comes for his show cause. Thank you.
if I may, Judge, I recognize I have no actual power to object to a competency referral. And I recognize that. But the way that this was handled, it is one thing to inconvenience me, and I have a lot of respect for the neighborhood defender services. There are several of them here at this courthouse that I have so much respect for.
Me too.
But how this was handled was completely inappropriate, and I told Mr. King that until there was an actual issue in court, we were here, we were ready to go, and I'm at a loss, Judge, because ethically as a prosecutor, I know that I cannot push to proceed when there is a genuine referral for competency. I don't want to compromise my ethics, but this is extremely difficult for the position that we are in, and the reason we're in this position is because of Mr. King.
If I may, Your Honor.
Translation, he's going to be held in contempt and locked up.
Yeah.
Go ahead.
Well, thank you, prosecutor, for the procedural history, and I can't speak to the conversations that the prosecutor had with Mr. King directly. However, I will remind or just say that at the times and moments that Mr. King was stating that he did not intend to refer to competency until after buying over, that those were true statements, and it wasn't until understanding the actual, and not to get into privileged communications and client confidential conversations that we've had, that even at this preliminary examination, even if it is probable cause, and even though he's told the prosecutor that we don't intend to refer to competency until later, it was clear that Mr. Littleton has an issue understanding the order, nature, and proceedings, as well as not being able to assist rationally in his defense. So it's not to say that Mr. King wasn't being honest or truthful, but
He was being lazy and unprofessional, counsel. He never spoke to the defendant.
Your Honor,
Unless she's lying to me, King told her he'd never met with Mr. Littleton. Other people from his office had.
I wasn't part of that conversation. I can speak to them. I'm not
Then I'm going to take her at her word.
lying. I'm just saying that all the other times that she was speaking with Mr. King and he made the applications and the intention of holding this exam, that was his intention. It wasn't to be dismissive. He wasn't refusing to communicate, that he was figuring out.
Counsel, stop, or I'll hold you in contempt.
Just want to make my argument.
Keep talking, I'll hold you in contempt. I'm not going to let you make your argument because you don't know what you're talking about. You're not talking from firsthand knowledge. She is. Sit down. Counsel, don't test me.
I'm sorry.
Sit down. You're done speaking today.
Done speaking today?
Yes, ma'am. Who flew in?
Judge, the complaining witness in this case, her name is Nora Al-Thamna, that's spelled N-O-U-R-A, last name A-L dash.
All right, I'm going to want her in here in just a minute. Do the pay.
Yes, this is like a rite of passage for young attorneys. It's not exactly hazing; it's more a baptism by fire. Wherein old attorneys send you in to catch their grief for their laziness or stupidity, knowing full well the judge will probably take it easier on you, knowing it's not your fault, and then calm down a little bit so when that you do actually show up, the problem has already been revealed, and the emotion's a little bit lower. Yep, that's how this works. She's doing a good job. She's taking a swing for her boss, but she doesn't know what to do. Judge Oakley is absolutely on top of this. Absolutely on top of this. This is disgusting. Most judges will hate this. They flew a victim in from out of the country. Flew her in to face whoever victimized her. And then they pull this crap where they say, oh, we want a competency evaluation on the date that's set for hearing. No. That's a hard no.
Paperwork so we can send Mr. Littleton for his competency, which will be 6 months down the road before we hear anything. You guys can take Mr. Littleton back into lockup. Bring your complainant in.
Yes, they have to do a competency if it's raised. Well, actually, I don't know that. I don't do criminal, but likely that's the case. But sandbagging everybody, making them fly in a witness, and not mentioning that ahead of time when the prosecutor got ahead of the issue and called, that's unethical. Plain and simple. That is unethical. And that's why everything the prosecutor said, by the way, the prosecutor went out of her way, as you would expect, to say, I don't have a problem with this young associate who got sent in here for this horrible mission. But what I do have a problem with is I've been trying to get to the bottom of this for a week because I have to bring a witness here. And you have to understand that this stuff is important, because if the prosecutor doesn't get the witness here, the defense is standing up saying, oh, we want to dismiss this case. We want this case dismissed. The state isn't ready. They're not prosecuting it. So it's absolutely unethical. There's no two ways about it.
What's all the nine?
Oh, I've been sent in when I was young. It's hard to believe, but at one point I was young, and they would send me in and tell me the situation, and I knew what it was. And they'd just be like, clearly it's not this kid's fault. And I'd have to bat my eyes and pretend to be confused to diffuse the issue. It wasn't fun. But it makes you an attorney. The dopey boyish thing doesn't work for me anymore. But I got to sell a decade out of it. Now I'm just old and cranky.
Sheriff, do you want to come up?
Please.
Podium?
Just podium, yeah. Right here, ma'am. Right here.
Yeah.
Did you tell her what happened?
I did not. I told her that there was an issue and he wanted to see her and that I would explain after.
So we're not going to have an exam today. I wanted to apologize to you personally for making you show up and put you through this and have nothing of substance happen. I also want to know exactly, with documentation to counsel, what it costs you to show up here today. Because if I find the attorney in contempt, I'm going to charge him for your costs.
And I will.
You understand that? All right. I just wanted you to hear it from me personally that I apologize on behalf of the system. I apologize to you because
Oakley is an excellent judge. I've seen a ton of his hearings. I can't think of anything I disagree with, but you'll always disagree. He's not going to make all the calls I would expect at all times or whatever. But by and large, he is a top-notch judge, swinging, doing the best he can to be fair to everybody. He really is.
system is not treating you well. Thank you, counsel.
Bring it.
Ms. Moore, anything else?
Thank you. And again, I just want to acknowledge that I do not believe that Ms. Farage did anything. She's just said.
I don't disagree. Thank you. What's next?
Sydney Bess. Sydney Bess. Okay.
It's somewhere, it's bondable.
Okay, that was the main event. I'm not going to lie to you. I've got some more stuff here, but it's mostly Sunday hangout. Right here, he's not here today, but I think I have found the perfect girlfriend for Andrew.
Yes.
Is bondable?
Yes.
Make sure. You didn't say it.
All right.
Oh,
We ready to proceed with Ms. Bess?
Yes, Your Honor. Your Honor, in Ms. Bess's case, the state is seeking $10,000. This is a Category B offense, so we would ask for no 10% cash alternative per the administrative order. We would also ask for DAS supervision along with a no contact order with the rogue casinos, as well as a GPS device prior to release. And I'll explain why that's important. Obviously the underlying conduct itself is very violent. Ms. Bess acted very violent towards law enforcement, towards security. She scores highly on the risk assessment at 11, 1 point for failure to appear. She's got numerous prior misdemeanor convictions. She resides outside of our state. I can tell you that she has 2 active bench warrants for her arrest. One was issued in 2024 for a DUI out of Las Vegas. And the other one was also issued in 2024. It's for a trespassing, also out of Las Vegas. Just this year, she was convicted of disturbing the peace out of California on May 29th. She was arrested for domestic battery in Oakland in April of this year. There's no disposition for that case yet. In 2024, she was arrested for a DUI out of Las Vegas. I believe that's what the warrant is related to. She also has a conviction that same year for grand theft from a person out of California. She has a very long history. So she has misdemeanor convictions for false ID to a police officer in 2023. That's out of California. In 2022, she has 2 different trespassing convictions out of Reno Municipal Court. On one of those, she failed to appear and admitted her failure to appear with a resisting charge as well. In 2016, convicted of loitering with the intent of prostitution out of California. She's got a disorderly conduct prostitution conviction in 2009 with another obstructing and resisting out of California. She has a misdemeanor conviction for trespassing and failure to appear out of Sparks Municipal Court. And then 2 more trespassings out of Las Vegas Justice Court, one in 2018, one in 2015. And then finally in 2014, convictions for solicit to engage in prostitution out of Las Vegas, 2 different cases, convictions for that, as well as a trespassing conviction, again, out of Las Vegas in 2014. She also has an extensive juvenile history reported out of California, some of those also revolving around prostitution. So based on that large criminal history, as well as her outstanding bench warrants, high MPRA score, state believes that $10,000 with no 10% cash alternative and the previously mentioned conditions are appropriate.
Hey, Mr. Merritt.
So in this instant case, we're seeking an OR release with appropriate release conditions. Given her out-of-state standing, we would ask for DAS check-ins, and then a no weapons clause, just given the nature of the charge, and potentially no contact with the alleged victim, albeit that's never really an issue with this type of case. While she did score an 11, in that 11, there were no prior felonies and no violence indicated in the MPRA. I think that reflects that this is kind of out of her wheelhouse, out of the ordinary conduct that Ms. Bess engages in. Beyond that, we were able to reach a contact for her. That reference was able to verify her job, housing, and personal phone number, marking her down from an 11 to a 7. That puts her at a mid-moderate risk rather than a high risk. I think with that change in the MPRA, plus the way in which she scored on the MPRA, I
have to say, I watched a bunch of this call. This defense attorney is excellent. He's got he's got a group of clients that would make Darren Patterson cry. They're all like trouble, big time. Like not like, oh, I got a speeding ticket. And he's just real calm and makes everything sound like it's not a big deal. And knows his stuff on like defendant after defendant after defendant. So I don't know who the guy is or whatever. I'm just saying this guy's swinging over there.
think she makes for a relatively fit candidate for an OR release with appropriate check-ins and other release conditions. I think if the court is inclined to entertain an OR only on the condition of a GPS monitor, I believe Ms. Bess would be willing to engage with that if afforded that opportunity. I do think that that would be the least restrictive means to monetary bail given the circumstances. And so with that, defense will submit.
All right. Well, again, she was asked multiple times to go to her room. I'm not even sure she even had a room, but the long and the short of it is, and she resisted from beginning to end, both with security as well as the police department, and spit multiple times on each one of them, or attempted to. I'm going to set the bail at $10,000, no 10% cash option, no contact with the Silver Legacy, El Dorado, and Circus 501 North Sierra Street. She will be fitted for a GPS monitor before release. She'll be subject to testing, and she'll have supervised check-ins with DAS, given the circumstances of this case. All right.
Or 10,000.
Next individual.
Don't foul this up. I'm giving you a break.
I will not. I really appreciate it, Your Honor.
No problem. Okay, let's go to Alenda.
I'm warning you, nothing happens here. We just got a cranky old judge I like because he he's got a t-shirt, he's chomping on a Zin, and he's getting through his damn call, and that's that.
Nash. City's offer.
Yeah, sure. You do chair, man.
Just 1 second, please, Your Honor. So a traffic ticket, Your Honor, for no insurance, no license. If she were to plead to both charges, the city would just recommend the statutory amount on the no insurance and standard fines on the license. She could have time to cure either one.
Got it.
And credit time served on the failure to appear.
Okay, Miss Nash, you there?
Yes, sir.
Would you plead to no insurance?
Guilty.
Would you plead to no driver's license?
Guilty.
Okay, do you admit failing to appear on July 11th of 2022? Say,
Yes, sir. I'm deaf in my right ear.
okay, I'm giving you time served on the FTA. Did you ever get insurance?
No, I ended up in hospital. I had a
How long you been in jail?
3 days.
All right. All right. On the, are you working?
No, I stay in a homeless shelter.
Yeah. All right. This is what I'm going to do on the insurance. How many days you been in jail? 3 days?
Yeah.
Okay. I'm going to give you the failure to appear. It's going to be 1 day, Washoe County Jail. On the insurance, I'm going to give you 3 days, Washoe County Jail. Any extra credit time served will be applied. And on the driver's license, I'm going to give you 1 day, Washoe County Jail. Do you understand? They're all to run consecutive. Do you understand?
So I go back to jail?
You're going to be in jail a couple of days and they'll let you out. I'm not putting any conditions on because it would be an effort and futility. Do you understand?
Is there any way I can keep my bed at the homeless shelter? I'm staying at our place.
Listen, I'm giving you the minimums.
Okay.
Okay, so you're going to do a couple more days and then you can go about your life. Thank you.
Thank you.
You bet. We already did Octobia Alberete Leonel. Okay. Douglas Amaya.
Morning, Your Honor.
Good morning. Okay. Plead to one of the driver's license, Tyler?
Yeah, he has 3 cases, 2 from 2025 for no license, 1 with no registration, and then a 2021 case for failed to maintain lane and driver's license. He can plead to 1 of the driver's license. Just give me 1 second to see if that failed to maintain lane was.
Yeah, because that one on 1542, I don't have any charges noticed. It's blank.
I'm sorry, the system kicked me out real quick, Your Honor.
All right.
Just 1 moment.
I'm showing that 15420. He's already been pled and been sentenced on it.
Okay. You want to plead 1 driver's license, give him time to cure?
Yeah, that's fine.
Okay. All right, sir, on 06848, what's your plea to no driver's license?
Your Honor, I'm gonna get my license back.
Okay, I'm going to help you out here. What's your plea to no driver's license?
No contest, sir.
Okay. On 07281, driver's license, that charge is dismissed, registration's dismissed. What I'm going to do, sir, it's going to be, you're going to get out of jail today. How long you been in jail?
Around a month, sir.
A month?
Yeah, I'm doing another charge for justice.
I'm going to give you 2 days Washoe County Jail credit time served. It'll clear this matter up. Thank you, sir.
Thank you, sir.
You betcha. Okay, let's go to.
Judge, I'm sorry to interrupt. Mr. Davis is here and Judge Champagne.
So?
We have to take care of 1 case.
No, tell them to wait till tomorrow. What case is that?
I agree. So.
Okay, hold on a second. We did Argueta Vasquez, didn't we?
Yes.
Okay, and so the next one, so I can find out where I am since I'm getting interrupted, is Banks. Okay, go ahead, Judge Champagne and Mr. Davis.
That was kind of fun.
Thank you, Your Honor. All right, we're going to call one out of order. This is Antonio Gonzalez Chavez, case number 25CR04410. Judge Draculich, thanks for letting us jump in. This is just a case where we had him last week on a DUI. He's got an immigration issue to deal with. And so I knew the case, and I just wanted to go ahead and clean his case up for him today.
Here, go ahead, please.
All right. So let's see. I did receive the substance abuse evaluation that was prepared by
Go ahead. I got to pop a fresh Zen here.
Ms. Dawes. We have already admitted the prior on this case. I do have on my records here, Mr. Chavez has been in custody for 124 days already on this matter. So, Mr. Alton, what's the city's recommendation?
Your Honor, we'll just submit it for the court's standard DUI second offense penalties with his ice hold and the time that he's been in. Whatever Your Honor orders compliant with statute would be fair and just.
All right. Mr. Davies?
Thank you, Judge. I think the best thing to do is apply his credit time served to everything that you can apply it to. Fines, jail times, leaving him a balance of victim impact panel and DUI counseling, and of course the breath interlock device. That'd be our request.
All right. Mr. Chavez, is there anything that you want to say?
No, not really. Everything has been done by last week, so I was just questioning the interview that I had. She mentioned in the classes that I need to do once I get released from here and ICE. He wasn't really clear on that, so I'm assuming you're gonna go through that.
Yeah. Let me just honestly, I'm assuming that you're probably going to be deported, correct?
Probably not.
Not. You think you're going to be able to stay here?
Yes.
Perfect. Okay. That makes all my, if I thought that it was a lost cause and you were just going to be deported, I would think maybe we would just give you time and not have you do any classes. But if I can give a chance for you to get out of jail, deal with immigration and do the classes here, that's great. I'm sorry. Go ahead.
The only part is that it might take me a while for me to get out of ICE situation too. So I just don't want to get out in a month or 30 days or whatever, and get to Reno Municipal Court and says that I have a warning. You know what I mean? So
absolutely, and I will make notes on here. I've already had that you've got immigration to deal with. We will give you all the time that you need. You just get in contact with us as soon as you get out of custody. Okay.
Perfect.
All right. Okay, so for the DUI second, I am going to fine you $1,143 plus a $60 chemical analysis fee. I'm going to take 8 days. I'm going to give you credit time served. Against all of that, you will, against the 1143, you will still owe the $60 chemical analysis fee. You will do 10 days in jail. I will give you credit time served for 10 days. You will do a victim impact panel. You will complete a level 3 DUI school. That means a minimum of 1 year of treatment. You're going to have to go to class once a week for a year. When you get out, you come down to the municipal court, you meet with the marshal, they'll help you set all of that up, okay?
Perfect.
All right, you must also install a breath interlock device on any vehicle that you own or any vehicle that you operate for a period of 12 months. You will remain drug and alcohol free. You will obey all laws. I'm not putting you on a suspended sentence. I'm just telling you that if you get in trouble for drinking and or for some sort of issue where you're driving illegally or you get some other charge, I can hold you in contempt and you could do an extra 25 days, okay?
Got it.
All right. You are done with me. This case is, you are released from custody on this matter. When you get out of custody within 48 hours of your release, I want you to come in and check in with the marshals and get set up on all your supervision things, okay?
You bet.
All right. Did I cut somebody off there? Did I miss something?
All good, Judge. Thank you.
Okay. All right, Mr. Chavez, good luck. Counsel, thank you. Judge Draculich, thanks for letting me jump in.
Thank you. Thanks, Antonio. Come see me when you're done.
Good job, Mr. Dave. You did a lot of talking.
All right. Thanks, Judge.
Thank you, Mr. Judge Champagne. Okay, let's go to Hina, whatever. Banks, B-A-S, it's 10679.
Whatever.
Take it, Keith, this will be not guilty.
That's correct, Judge. We can ask for bail consideration.
Okay. Mr. Banks, you there?
Yes, I'm here.
What's your plea to the domestic battery?
Not guilty.
Did you apply for a legal defender?
No.
He did, Judge, and he does qualify.
Okay. Go ahead on bail, Keith.
Judge, Mr. Banks is 18 years old. He's lived in Reno almost his whole life. He has employment at the locker for the last 2 years. He has no prior criminal history. He understands that a no contact order would probably be imposed as a condition of an OR release. And he says he indicates he understands what that means and can abide by that requirement. He has a place to live. He has his own apartment, which is not where the victim lives. So he can live in a place separate and apart from Ms. Hunt. And so we'd ask the court to consider releasing Mr. Banks on his own recognizance.
All right, Tyler?
Thank you, Your Honor. City will be recommending $1,000 bail. He does score, in all frankness, he scores low on the risk assessment, has no criminal history. He's 18 years old. The reason we are asking for bail is the facts were pretty violent in this case. It's on video, and there were at least 2 other witnesses.
No criminal history is 100% the product of him being 18 years old at this point. You commit a violent offense on video at the age of 18, and the best thing you got to say is, I don't have any criminal history. Okay. Well, you've had a few days for it to develop. It looks like we're getting there, though.
So the likelihood of conviction goes up per NRS 178. So those are some factors the judge, Your Honor, can also take into consideration when making a bail determination. So we're asking for $1,000, no contact, no alcohol or drugs.
All right, Mr. Banks, it's going to be $1,000 bond. You make that bond, you report upon release to the Reno Municipal Court, pre-trial, obey all laws, no drugs or alcohol, and no contact in any regard with Mrs. Hunt. Don't call her, don't text her, no third party, don't have friends or neighbors contact her. Do you understand?
I understand.
All right, trial date, legal defender.
His pretrial conference is set for September 9th at 1 o'clock. Mr. Puentes is his legal defender.
Thank you, sir. Okay, let's go to Todd Boudreaux, Boudreaux.
Morning, Your Honor.
Good morning, sir. What's your plea to the obstructing and resisting?
What's that what?
What is your plea to the obstructing and resisting charge?
No contest.
All right, City.
Your Honor,
All right, I'm getting strong Louisiana vibes here.
I'm not sure what his arrest date is. He does have a priority 1 PMP hold, it looks like.
I've got July 23rd.
Okay. We'll submit, Your Honor.
All right. Keith?
Judge, he reports that the parole hold has been lifted as a result of meeting with this parole officer yesterday. He does work part-time doing construction. He has a wife that he does provide support for. He is homeless and unemployed other than the part-time construction work, and would like to attend community court.
Actually, about the community court, I was thinking I'm set to go into WellCare. I was set to go into WellCare this week, so I don't know. I think they're supposed to provide resources for me and stuff, so I don't know if.
How long you been in jail?
I've been in jail since last Wednesday, 7 days.
I'm going to give you time, sir. Thank you, sir. Okay. Let's go to Curtis Brewer, BREWER, 10372. What's the offer? Plead to the O&R, dismiss the urinating?
Yes, sir.
Okay. What's your plea to the obstructing resisting, sir?
No contest.
Okay. The urinating in public is dismissed. City?
Just 1 second, Your Honor. Looks like he's been in since the 23rd. Would submit it, Your Honor.
Time served. Thank you, sir. Behave yourself. Go to the bathroom in a regular stall. Antonio Chavez, did we already do that?
Thanks for that succinct wrap up, Judge.
Did
we did, Your Honor.
What's that?
We did. That was with Mr. Davies.
Oh, got it. There we go. Larry Clausen. Mr. Clausen, you there?
Yep.
All right. You admit failing to appear on April 2nd of this year? Do you admit not showing up?
Yes or no? Yes.
Okay, what's your plea to smoking marijuana in a public place?
No contest.
All right, how long you been in jail?
2 days.
Time served. Thank you, sir. Okay. Oh, I'm sorry. You've got another charge here. How many charges do you have? Okay. On the other charge, you've got, do you admit failing to appear on April 16th?
Plea no contest.
Do you admit failing to appear?
Yeah.
Okay. What's your plea to paraphernalia charge?
No contest.
All right. I'm going to give you 2 days on each of those. It'll be 4 days. And that'll run consecutive to the other time served that you just did. Thank you, sir.
And he's
If
in
you
also.
didn't know, y'all stink. Okay.
Then credit will be applied. Thank you. James Klein.
Non-user refusal.
Okay, bump it a day, no bail hold. David Finn. Is this a DUI with a, no it isn't. Yeah. David Finn. Harley.
Harley.
What's your plea to the paraphernalia charge?
What?
What is your plea to the paraphernalia charge?
Paraphernalia. I just
Paraphernalia.
had a DUI is all this.
Are you Harley Finn?
Yeah.
Okay, I'm sorry. We've got other, okay.
He does have a paraphernalia case. He has 2 cases, Your Honor.
Okay, what's your plea to the paraphernalia?
No contest.
How long you been in jail?
4 days, 3 days.
Okay, I'm going to give you 2 days jail. That'll be credit time served. As far as the DUI, what is your plea to the DUI?
Am guilty?
Did we get a waiver on that?
Yeah, I signed the waivers.
Okay, I'm sorry. You completed a waiver of rights form, is that correct?
Yeah.
Did you understand that form?
Yes, sir.
Mr. Loomis was there. Had you any questions?
No.
Okay. Pages 1 through 4, there's initials in the left-hand column. Your initials?
Yes.
Okay, the last page, there's the signature. Is that your signature?
Yes, sir.
All right. You enter a plea to a criminal offense. You give up your right to a trial. Give up your right to compel the city to prove the case beyond a reasonable doubt. Give up your right to have your attorney cross-examine the city's witnesses. You give up your right to mount your own defense, call witnesses in your own behalf, testify on your own behalf.
Yes, sir.
Went to trial and you didn't testify, wouldn't have held it against you. That's your right to remain silent. Misdemeanors carry that up to 6 months in jail and up to $1,000 fine. This is an enhanceable offense. Any other DUIs, Tyler?
No, Your Honor.
Okay. You get another DUI within a 7-year period of time from July 26th of this year. It's still a misdemeanor, but the penalties are tougher. Sanctions are tougher. If you get a third DUI within a 7-year period of time from July 26th of this year, it's a felony and you can go to prison. Do you understand that?
Yes, sir.
All right. And what's your plea to the DUI?
Guilty.
Okay. City?
Your Honor, he scored a 10 high on his risk assessment. His last release date was July 21st, 8 days ago. He was found passed out at the Wendy's after using meth, fentanyl, and marijuana. He just sounds like he pled to that paraphernalia case as well, which he may have already
I mean, that could happen to anyone. Let's be honest.
pled to that because that was a fairly
Many times served on it.
Yeah. But I assume he's pleading under the influence because it's drugs. We don't have the results yet. We're going to ask for a 120-day suspended sentence. We're going to ask that he be on enhanced testing for at least a month. Obey all laws, no alcohol or drugs, and the court's other standard DUI first offense penalties.
Okay. All right, Mr. Loomis.
Judge, Mr. Finn, he's 25 years old. He's been in Reno here for 7 months.
Are you kidding me? This guy is 25 years old. Take a look at him when we go back to him. That's a rough 25.
I don't really see the need for a 120-day suspended sentence for this charge. I mean, that's he does indicate a desire for substance abuse treatment. I don't know if that's something that he can look into on his own, or if the court wants to get involved in that. But Other than that, I would concur with the recommendation from the city.
All right, anything you want to say, Mr. Penn?
Yeah, if I may say myself, I was seeking substance abuse treatment personally after I got out anyways. Like I was personally going to seek that type of treatment.
This is what it's going to be. You're going
I'm filled with confidence. I don't know about the rest of you.
to report upon release to the Reno Municipal Court when you get out of jail. You're with the drugs involved. I'm going to give you 90 days jail. That's suspended for 2 years. You report upon release to the Reno Municipal Court. Go to court services for their recommendation on the type of testing you will do. You're going to obey all laws, no alcohol or drugs, breath interlock device for $185 days. You're going to pay a fine of $525 plus $60 for the testing. Do you understand?
Yeah. Can I ask when would I be released?
You're going to be released today.
Okay. Thank you, sir.
Make
Your
sure.
Honor, he needs to do a victim impact panel and DUI level 1 as well.
Oh, I'm sorry. There we go. Victim impact program, level 1. No, well, we're gonna, level 1 alcohol. Your testing through the court will be for 60 days upon your release.
Okay.
All right, thanks.
Thank you.
All right. Okay, let's go to.
All right, that's all I had. I told you I was trying to find some fresh Sunday stuff. Although that guy's kind of fun. He really was. He really is. I like so was good. And also when he he calls a case and he's got some defendant, he's like, whatever. Whatever. Just step up to the mic, spit your BS. If you've sat in the cooler long enough, in my estimation, I'll cut you loose. If you haven't, well, too bad. But move it along. Yes. Au suivant. Comme on dit en français. All right. Thank y'all for coming out. I appreciate it. I will see you soon.